This week in U.S. immigration news, we are going to cover employment-based categories, temporary protected status for Afghan evacuees relocated from military sites, remain in Mexico dispute, public charge lawsuit, immigrant investors filed suit against the Biden administration, bipartisan infrastructure bill. U.S. Citizenship and Immigration Services encourages eligible applicants to consider requesting to transfer the underlying basis of their adjustment of status application to the first or second employment-based preference categories. There is an exceptionally high number of employment-based immigrant visas available in these categories during this fiscal year. For this fiscal year, the overall employment-based annual limit is twice as high as usual because that limit includes all unused family-sponsored visa numbers from fiscal year 2021. Any visas not required in the fifth employment-based preference category are made available in the first employment-based preference category, and any visas not required in the first employment-based preference category are made available in the second employment-based preference category. The Biden administration is considering granting temporary protected status (TPS) to Afghans currently living in the United States. Advocates have been pushing the administration to provide more protection and a pathway to citizenship for Afghan evacuees. Over 70,000 Afghans have arrived in the U.S. since the evacuation. Many remain in a legal limbo, with some given less than a year to prepare their paperwork to stay in America. A TPS designation would help those already in the U.S. as well as offering a short-term solution for those evacuated and running out of time to secure their status. TPS does not offer a pathway to citizenship and is instead reissued in increments, leaving recipients unsure of whether their designation will be renewed. The Biden administration relocated the last group of Afghan evacuees from a military site in New Jersey, completing its 6-month-long operation to resettle Afghans. The U.S. worked with non-profit resettlement agencies and groups of private citizens to resettle Afghans across the country in over 200 communities. The last military site, Joint Base McGuire-Dix Lakehurst, had evacuees depart on Saturday morning to relocate to their new communities. The military bases provided halal food, faith-based services, English classes, vaccinations, immigration paperwork assistance, medical services, recreation, and schooling for children. The U.S. Supreme Court on Friday agreed to hear President Biden's argument to revoke the Trump administration's "Remain in Mexico" policy. The immigration policy forces migrants to stay in Mexico while awaiting their U.S. asylum hearings. The justices will hear a Biden administration appeal of a lower court ruling which reinstated "Remain in Mexico." The Biden administration, in its appeal to the Supreme Court, said it is being forced to reinstate and continue implementing indefinitely a controversial policy that exposes migrants to safety risks, harms relations with Mexico, and is not the most effective measure to deter illegal immigration. The administration further argues that the lower courts are unacceptably interfering with the historically broad authority the U.S. presidents have over immigration and foreign affairs.
If you are new to our channel, welcome and please subscribe to stay in the loop. We offer free 15-minute consultations if your case is qualified so we can point you in the right direction. Stay tuned for the secret code later in the show.
U.S. Supreme Court justices debated over whether to let Republican state officials defend a Trump-era immigration law that barred permanent residency for immigrants deemed likely to need governmental benefits. The justices heard oral arguments in an appeal by 13 Republican state attorneys general led by Arizona Attorney General Mark Brnovich. They are appealing a lower court decision that rejected their attempt to defend Trump's rule, which expanded the scope of those considered likely to become a public charge. The Biden administration dropped its defense of the policy, resulting in the action by the states. A group of investor immigrants filed a lawsuit against the Biden administration claiming it is unlawfully refusing to process their valid visa application and green cards after Congress allowed a major visa program they participated in to lapse. There are more than a dozen plaintiffs in the complaint, which was filed in Seattle federal court on Thursday. They claim that a program earmarking EB-5 visas for investors who pool money has expired, yet federal law still requires USCIS and the Department of State to process their applications, which were filed before the expiration. The EB-5 program permits foreign citizens who invest $1 million in a U.S. business or $500,000 in an economically depressed area and create at least 10 jobs to qualify for visas or green cards. The Biden administration's historic $1 trillion bipartisan infrastructure bill is an investment to upgrade ports, restore bridges and roads, improve public transportation, and provide broadband access. The American labor market does not currently have enough workers to fill the vacant positions of the thousands of new jobs created by this law. With the shortage of workers to fill these positions, the U.S. must revamp its immigration system to allow American companies to recruit workers with the necessary education and experience. There are an estimated 10 to 12 million undocumented workers already in the U.S. who could help fill these positions.
Friends, show us some love and smash the like button. It doesn't cost you anything. If you have an immigration problem or need a second opinion because you cannot get a hold of your own lawyer, schedule a meeting with our team. Share information with our CARES team and they will help you get scheduled with our legal team. Now here's a secret code to unlock the free 15 minutes.